Good day, Crime Talk aficionados. It is Sunday, but we have a recap of all of the top stories from the week of October 21st, 2024, all conveniently located in one location for you. Thanks for watching. We'll see you next time. Enjoy the show.
All right, lawyer.
Go to crimetalksearch.com. Sign up for that background subscription service today. When you do, you're going to be able to do a background search on as many people as you desire, as long as they're here in the United States. You are going to get information about their relatives, their neighbors, their jobs, their education, social media, possible emails. I always think this is interesting when people have multiple emails. Why? Because that's the email for this dating app, that dating app. Ever wondered if your spouse has a bunch of extra emails he doesn't tell you about? You may want to check it out. If somebody's coming new into your life, do they have a criminal history? Are they on one of those public registries you hear so much about? You probably want to find out. So go to crimetalksearch.com, sign up for that background subscription service today. Like I said, you can do as many background searches on anyone, cases that we talk about, witnesses, defendants, victims. You can check them all out on crimetalksearch.com and cancel at any time. And first on the docket is Richard Allen. So a motion in limine had been filed by the defense that seeks to prohibit testimony of the enhanced audio. According to the motion, the defense says allowing a witness to speculate as to the words and sounds on the recording would put ideas in the juror's head that would be confusing and misleading. Further, defense says that the enhanced video were not used to identify Mr. Richard Allen as the suspect and therefore are completely irrelevant. Seems to make sense. Isn't that what the prosecutor was saying as it relates to the sketches? Hey, if you didn't use it, shouldn't come in. This is going to be a trial decision if the appropriate foundation can be laid. Basically, the audio should probably be played and the jurors can hear for themselves what they think they hear. They should not be allowed to have somebody come in and say, oh, I listened to it really closely, and this is what it says. That is the job of the jury. The jury can then decide how much weight to give that particular evidence, if any at all. So here's what we do know from the Delphi trial. All right, so here's what we do know also about the Delphi trial that has started. Richard Allen obviously is charged with the murder and the deaths of Abby Williams and Libby German at the Monon High Bridge back in 2017. Now, this video that they're talking about was taken on February 13th of 2017, and it was found on Libby German's phone by investigators the day after the murders. Now, early in the investigation, the Indiana State Police released this video that showed the suspect, known only as Bridge Guy, walking along the bridge behind Libby and Abby. Police also released an audio clip from the same video in which the man believed to be the Bridge Guy is heard saying, "Guys," followed by "down the hill." Now, defense says the prosecution plans to introduce the video and audio enhancements of the original video, which will contain audio of a man speaking and alleged audio of the victims played repeatedly on a loop. The video, like I said, is taken back in February, was found on Libby German's phone, and investigators found that days after the murder. A jury of 8 women and 4 men will have to decide what weight to give those statements if they are in fact heard. But we do know, we heard from opening statements in the Richard Allen trial. First, that the Carroll County prosecutor, Nicholas McClellan, had an opening statement that went about 15 minutes. He told the jury that this case is about 3 things: the Bridge Guy, a bullet, and a brutal murder. The rule of 3, ladies and gentlemen, so people can remember that. Bridge Guy, bullet, brutal murder. BBB, like snap, crackle, and pop. Remember that. That's your trial tactic lesson of the day. All right. And the prosecutor said that Allen used a gun to force the girls down the hill before killing them, and his intent was to have his way with them, but got interrupted somehow. And that Mr. Allen left behind a clue, a bullet, in fact. The bullet that we know that they say matched the gun that was found at Richard Allen's house. Now, McClellan also told the jury that they would hear Allen placing himself on the bridge and unsolicited, unprovoked admissions to the crime. He said, quote, "You'll hear Richard Allen in his own words telling his wife, his mom, and others that he did it, how he did it, and why he did it." Now, in Allen's defense attorney's hour-long opening statement, Andrew Baldwin said that Allen confessed to a crime that he did not commit after suffering trauma from the investigation and his ultimate incarceration. Richard Allen is an innocent man, Baldwin said, and the evidence is going to prove that. He also said that. Baldwin said that the girls were not shot, but instead insisted their throats were cut. Richard Allen confessed to shooting these girls in the back, but they weren't shot in the back. Richard Allen confessed to a crime he didn't commit. Richard Allen said he killed his family and his grandchildren. His lawyer argued he doesn't have any grandchildren and his family wasn't killed. Richard Allen allegedly confessed to raping them and burying them in a shallow grave, which the defense alleges never happened. Baldwin said there was a hair found in Abby's hand that did not belong to Richard Allen. Perhaps that of the real murderer, perhaps. So that's the highlight. Remember, opening statements are not evidence, but it is there to provide a roadmap of what the parties, the prosecutor and the defense team, believe the evidence will show. Now remember, as a prosecutor and as a defense attorney, you don't want to make promises that you cannot keep. So you keep it simple. You don't make promises you don't keep. Because why? If you say something and you don't deliver, the other side's going to get up and say, they promised, they didn't deliver, don't trust them. So the first witnesses in the case. First, the Delphi police chief, he's now former police chief, I should say, Stephen Mullen, testified about the search for Abby and Libby and when the girls were first reported missing. The former chief said the initial belief was that maybe the girls had fallen from the bridge and were somehow injured and they couldn't get home. And then on February 14th of 2017, authorities received a call about 12:15 from Pat Brown, who said he found two bodies south of the Morning Heights Cemetery. The jury also saw some drone video showing a human's view as they walked from Freedom's Bridge to the far end of the Monon High Bridge. Now, this video was taken or produced back only in 2024. Now, the Delphi resident, Jake Johns, who participated in the search, testified about finding a tie-dye shirt in the creek and alerting a fireman. John's coworker called Pat Brown, who knew that he lived on the north side of the creek, and asked him to walk down from the cemetery to investigate, leading to the discovery of the girls' bodies. Now, the Delphi resident, Pat Brown, who found the girls' bodies, said at first he approached them, he thought the bodies were actually mannequins. And the Carroll County deputy, Darren Giancola, who was one of the first police officers on the scene, talked about the scene where the girls' bodies were found. The officer also said he did not see their bodies as he walked south from the cemetery to the creek, but did see a multicolored shirt and one Nike shoe in the creek when he was being called to the scene. Now, Officer Giancola said Libby's body was unclothed while Abby's was clothed. Giancola recalled seeing a significant amount of blood on their bodies on the ground, and Abby's clothes appeared to be damp, presumably from crossing the creek. Now, Sergeant Jason Page was a crime scene investigator, and he testified and walked the jury through 44 police photographs that were taken at the scene. Now, Judge Gull, obviously not wanting people to have the truth about what took place in this particular case, has banned all cameras from the courtroom during the trial. And she's gone so far as to barring even reporters from using computers or phones in the courthouse. Unfortunate, ladies and gentlemen, the trial of the century in Indiana, and this judge believes that we're all too stupid to be able to see the evidence, view it for ourselves, and decide if Richard Allen is wrongfully accused or guilty of sin. Next, the Lori Vallow trial has been delayed again. Why? Well, Vallow's defense lawyer filed a motion for what is known as a Rule 11 evaluation. That's called competency, ladies and gentlemen. So on October 21st, Vallow's motion was granted by the judge. And under the Rule 11, the Forensic Service Divisions will evaluate Ms. Vallow for competency as it relates to stand trial in her criminal cases. Now, the judge is the one who ultimately ordered the evaluation. Now, 2 qualified mental health experts will be appointed to examine and evaluate Ms. Vallow. Her February trial is now vacated because everything tolls when competency is at issue. Now, as you may recall, Vallow's trial in Idaho was paused for some 10 months while she was restored to competency to stand trial. Now, in Arizona, both the prosecutors and the defense are ordered to provide medical and criminal history to the Maricopa County's Correctional Health Services Division, and 2 qualified mental health experts will be appointed to examine Ms. Vallow and determine if she is competent to stand trial. Now, really, normally to stand trial, you simply have to know the role of all the parties. You know, what does the judge do? What's the goal of the prosecutor, the defense? Do you understand the charges against you? Do you understand kind of the legal process? Very rudimentary when it comes to the legal system. But you also then have to be able to assist your attorney in the defense. I had a client once that seemed normal. We would talk and you'd spend an hour, 2 hours with him, and you would just think, that's 2 hours of my life I'll never get back. Ultimately, we comped him because we just couldn't ever talk about the case. He was found not to be competent, and after a certain period of time, with so many evaluations and the chances of him being restored to competency were so few, they dismissed the case. I don't think they'll do that in a homicide case, but just give you an example, that's a possibility. And like I said, as you may recall, in Lori Vallow's Idaho sentencing, she was diagnosed with a personality disorder and hyper-religiosity after she told the court that no one was even murdered in those cases. Oh, and that she talks to Jesus. So if she is found not to be competent, what is going to take place? They're going to have to try to restore her, usually through medications. But if she doesn't want to take the medications because it makes her feel tired, makes her feel funny, they, being the state hospital, then can ask for the medication to be forcefully given to Ms. Vallow. Needless to say, this case is going to drag on forever. Now, we did bring up last night on our live show. I want to thank everybody for taking the time to check us out yesterday. And really what it amounts to is her appeal in the Idaho case is due tomorrow. So the appeal in Lori Vallow's Idaho case is due tomorrow. I haven't seen any notices or requests for another extension, as they've already received 3 to file their brief. I would imagine maybe Arizona would lose a little interest in this case if the death sentence, or if the life sentence in Idaho is upheld. Ms. Vallow is accused of conspiring in regards to the shooting of her 4th husband, Charles Vallow, and plotting the attempted murder of her ex-niece's husband, a guy by the name of Brandon Boudreaux. Now, in the case of Charles Vallow murder, Lori's late brother, Alex Cox, argued self-defense to the police, but the police in Gilbert believes that Cox was also the shooter in the Boudreaux case. Now, Cox died back in December of 2019. And here, initially, the trial was scheduled to begin in August, but a judge later decided to push the trial to February. And despite Lori Vallow not wanting to waive her speedy trial rights, the judge set the matter much farther out, which has now been stayed as well. Now, as you also may recall, Lori Vallow was extradited to Arizona back in November of 2023 after being sentenced to life in prison without the possibility for parole for killing her 2 youngest children, Joshua J.J. Vallow and Tylee Ryan. Oh, and by the way, she was also convicted of conspiring to kill Tammy Daybell, who was Chad Daybell's former wife. And Chad Daybell is her current husband number 5. The lady is a black widow. So we'll see how long that's going to take to get her back to being competent. The Delphi homicide trial. That's right. Things are actually getting a little interesting. So it's been more than 7 years now since the bodies of Abby Williams and Libby German were found near the Monon High Bridge there in Delphi, Indiana. And Richard Allen, the man accused of killing the 2 teenagers, is standing trial and is now in the 6th day of trial. So the trial began on Friday, October 18th. And now 16 Allen County residents have been selected to serve on the jury. 12 of those jurors, 8 women and 4 men, began the trial as jurors, with 4 serving as alternates, another 2 men and 2 women as the alternates in this case. So at the trial today, we had the former Delphi police chief and the current investigator for the Carroll County Prosecutor's Office, Steve Mullins. He returned to the stand, and he said that he was called by the sheriff, specifically Sheriff Liggett, on November 21st, 2022, about Dullen's report on Allen. Dullen was another investigator. Now, Mullins said that he found Allen had a 2006 Ford F-250 and a 2016 black Ford Focus. Mullins said that he checked the video from the Hoosier Harvest store to see if he could see and find Allen's car there. Mullins said that when he went to the CVS where Allen worked to take the picture of his license plate, Mullins said in the review of the video of the Hoosier Harvest store, he saw Allen's car pull in at 1:27 p.m. on February 13th of 2017. Mullins also clarified that it was his opinion that it was Allen's car based upon the facts of the size of the car, color, shape, etc. Now, the jury was shown frame-by-frame video showing the vehicle that passed by the Hoosier Harvest store. You can't see the license plate or who the driver is in that video. Well, Mullins pointed out some of the features that led him to believe that it was Allen's car in the video. The hatchback profile, for example, taillights on the bumper, the black sport-type rims with distinctive spokes, and Mullins also said that the arrival matches when Allen told investigators that he had arrived. Now, Mullins said that on October 13th of 2022, he drove to Allen's home and spoke to Allen at his home with the sheriff. Mullins said that they told Allen that he wasn't under arrest, right? Significance of that is you don't need to read him their Miranda rights. Anyway, Mullins said that he took Allen to the police station with Allen's consent in an unmarked police car. And then he said then he said that he read Allen his Miranda rights at this point. Officers being overly protective, right? If you're not in custody, if you're free to leave at any time, you don't necessarily need to advise somebody of the Miranda rights. But if you get to the end of the interview and you want to arrest them, at least you know you've got a good statement there. So anyway, according to investigator Mullins, Allen said he went to his mother's house in Peru, Indiana on February 13th of 2017. He said he left his mother's house at 11 a.m. and then got his jacket and went to the trails. Allen allegedly told Mullins that he passed 3 girls and was looking at a stock ticker on his phone when walking towards the Murd High Bridge. Mullins said that Allen said that he arrived at the trail by noon and left by 1:30. Mullins said Allen claimed he went to the first platform of the bridge and looked at fish. Allen allegedly told Mullins that he saw the girls near the start of the trail and they passed him going to the opposite direction as he walked towards the Murd High Bridge. Now, Mullins said Allen told him he was driving his Ford Focus, the 2016 version. Anyway, Mullins also said that Allen told him he was on the trail for about an hour. And Allen allegedly told the investigator that Allen had told his wife that he was on the trail the day of the murders. Allen allegedly also told the investigator he was wearing a black or blue jacket, jeans, a skull cap, and some military-style boots. Now, Mullins said that Allen originally agreed to show investigators his phone, but then he changed his mind. Allen got irritated and left the room. Mullins said that he showed Allen a picture of the bridge guy and asked Allen if that was him in the picture. Allen apparently answered, "That's strange." He said Allen says if the picture was taken with the girl's camera, there was no way it could be him. Anyway, Mullins said he took Allen home and then applied for a search warrant. On cross-examination, Bradley Rozzi asked the investigator that first that obviously Richard Allen came forward. He agreed. He told you he was on his way to the grocery store. Yes. Dolan said that he didn't remember, but that was possible. And Rozzi also asked him to confirm that Allen said he was on the trail between 1:30 and 3:30 p.m. Dolan said yes. Do you know how long he was there? He asked. Dolan said he interpreted Allen's statement to mean he was on the trail the whole time based upon the interview. There was nothing that struck you as unusual, was there, about the interview? The investigator said no. There was nothing that would have led him to report Allen to law enforcement. Now, Dolan said there was the part that stood out to him was Allen saying he was on his phone on the trail. And Rozzi said that Dolan said nothing stood out during his deposition. He asked him if he was suggesting Allen was using an alias. When he asked again, the prosecutor objected. Now, Mr. Rozzi then asked Mr. Dolan, said that Dolan did not ask Allen what he was wearing or what Allen was driving. Dolan admitted that was correct. Now, Dolan said he was confident that Allen parked at the old building, and Rozzi asked him if someone can register for a fishing license or someone else can. He said yes. Rozzi asked him if there were several references to previous licenses being held by Mr. Allen, correct? And he was 5'6", 5 feet 6 inches tall. Yes. Rozzi then said during their deposition, said that he didn't think Allen was trying to be deceptive with the license information. The investigator agreed. The investigator said that he went to the crime scene multiple times, including early on, and the investigator said his first time was on February 17th when he saw the sticks and branches piled up at the crime scene. He said the sticks had blood on them, but the crime scene had been released, which meant that the crime scene tape was up, but it wasn't secured. Anyway, Dolan said that he called the investigative center to report the sticks with blood, and someone came and got the sticks. Now, Rozzi asked if he saw any deer stands in the area, and Dolan said that, in fact, he did. Rozzi asked if it was unusual to find an unspent shell casing in the woods, and he asked if Dolan told him it was not unusual during his deposition. Dolan said that's correct. Now, Rozzi asked if the Sig Sauer was a popular gun maker and Smith & Wesson ammunition was popular, and Dolan also had to agree with him because it is. And then Rozzi asked Mr. Dolan if he was able to find the IP address, email, and credit cards used to purchase Allen's fishing license. And he said yes, it was, and it was paid for with Allen's credit card, but he didn't know what the username was. Rozzi asked if the investigator looked at what was on Allen's phone, and he said no, he just asked Allen for his phone ID number. He says, you don't know he was manipulating anything or anything along those lines, do you? The investigator responded, no. So, defense scores a couple of points in my humble opinion. We'll see if it matters in the long run. Now, Dolan did say that the interview that he had with Allen lasted about 10 minutes and it wasn't recorded. Dolan also had to admit that he took notes during that, and he was asked if the phone numbers and driver's license numbers. Dolan also stated that he asked for the phone number and the driver's license numbers for Richard Allen, and that would mean the state had Richard Allen's information within 4 days of the murder. Now, the jury was shown Dolan's notes and Allen's driver's license pictures, along with a lead sheet from Dolan's interview. Now, Dolan said back in September of 2022, he received a call from Steve Mullen, the sheriff, asking if he remembered talking with Richard Allen. Dolan said that he did more research and found Richard Allen's fishing license information. He told the jury that on April 1st of 2017, Allen changed his height on his fishing license from 5'4" to 5'6", and decreased his weight. Now, Dolan also said that that stuck out to him because it was an uncommon thing to increase your height by 2 inches. The prosecutors asked Mr. Dolan to identify Mr. Allen in the courtroom, and then the jury also heard today from Kathy Shank. She was the volunteer file clerk who found Allen's file. So during her testimony, it came out that, to your knowledge, that Mr. Allen came forward to assist investigators, and she agreed. The state objected along the lines that this was a whole lot of speculation. Anyway, the defense attorney's cross also included asking Ms. Shank if she knew if the information was in the file was accurate. And she said she had no idea. She was just the file clerk who found it. Baldwin also asked her that there's no Richard Allen Whiteman, which is the name on the file. Shank said it wasn't me who wrote Richard Allen Whiteman on the file. Baldwin asked Shank if details were accurate and those matters to her, and obviously she said they did. Now, Ms. Baldwin then asked, many people reported seeing someone who looked like the picture of the bridge guy. Ms. Shank agreed. Baldwin asked Shank if Liggett was running for sheriff when she made the connection between Allen and the report of the man on the bridge. Now, the objection from the state was sustained by the judge, but Mr. Allen, the attorneys also were able to get to Mr. Allen self-reported him being on the bridge. They all agreed, and that was it. Now, the Richard Allen Whiteman, apparently that was what they put on the file name, which is why it probably got misfiled, so to speak. That failure attention to detail demonstrates an inability to accept larger responsibilities, apparently. But Mr. Richard Allen lived on Whiteman Street or Boulevard. So anyway, interesting day. Things are getting more and more interesting in this trial. Judge still has not ruled on whether the prosecution opened the door to allowing in the Odinist theory as well. We also learned from Ms. Shank that she started working and scanning documents, and it took her about 2 years to complete and put all the 14,000 tips into a database. And the prosecutors asked whether there was something that brought your attention to the name of Richard Allen. Apparently, this was the first time Richard Allen's name had been mentioned since opening statements back on October 18th. Anyway, Miss Shanks said that she found a lead sheet in a box, and this sheet said that on February 16th of 2017, Richard Allen Whiteman had self-reported being on the trail between 1:30 and 3:30 on the day that Abby and Libby went missing. Shanks said that she remembered seeing another tip that a man had been on the trail, and Shanks said she compared the tip to the file that had Richard Allen's name on it, and Shanks said she didn't know how the tip or lead sheet had gotten into this particular box. Anyway, she said that the narrative summary of the database said that Allen had been interviewed, the file had been viewed as cleared on it, and it had a green mark that indicated it was cleared. Shanks said she took the file to Liggett. Interesting, ladies and gentlemen. Oh, and on top of that, the judge has not ruled on whether she's going to allow in the Odinist theory that the defense believes the prosecution opened the door to. We'll let you know as things become available. And not a big surprise, but they had a verdict in the Lelani Simon trial. And guess what? It's guilty. That's right. Friday afternoon, a jury found Lelani Simon guilty of all 19 counts against her in the death of her son, Quentin Simon. Those counts include malice murder, felony murder, concealing the death of another, and making false statements. Now, the jury heard 8 days of testimony from witnesses, and they began their deliberations on Thursday afternoon. Now, the deliberations only went for about 2 hours yesterday, and the jurors came back today, and they reached a verdict after about 5 hours of deliberation today. As you may recall, Lelani Simon called 911 on October 5th of 2022 to report that her son was missing inside the indoor playpen at their home outside of Savannah, Georgia. After the police spent days searching the home and their surrounding neighborhood, the Chatham County Police said that the investigation believed the child was dead. He also named Simon as the sole and only suspect. Well, police and FBI agents focused their investigations on a landfill 2 weeks after the boy was reported missing. And those investigators sifted through trash at the landfill for more than a month before ultimately finding human bones and other pieces, which DNA had to be used to confirm that that was young Quentin. So she will be sentenced. Not good. Going to prison for the rest of her life. That's what happens when you kill your kids, ladies and gentlemen. There is a better way. If you don't like your kids, I'm sure there's somebody else out there that will be more than happy to take care of those children if you don't want to. There's lots of good people that want those kids.